Okay, so now that we've learned how to identify and define what negotiable instruments are, we're going to talk about the word negotiation, which refers to how these instruments are transferred and the proper way to transfer them such that the person who has it transferred to them can expect to be entitled to take payment on that instrument, whether it's a draft like a check that you write someone or a note for a loan agreement. These can be transferred to other parties, and we call that process negotiation. And then after that, the second part of the video, we'll talk about what happens when somebody forges their name to a negotiable instrument so that they can take payment on it, and how you go about rectifying that situation. Okay, so remember again the elements of what makes a negotiable instrument. We have here for a draft, it's paid to the order of whoever is named there. It's payable by a certain date, there's a certain sum of money, and of course it's unconditional and signed by the party making the instrument, who's making the payment. Now they're called negotiable instruments because they're considered negotiable, which in this context means they can be transferred to other parties who are entitled to take payment on it, even if the instrument wasn't originally written to them. So you probably know this already, but if somebody writes you a check for rent without even cashing the check and getting the money and transferring to somebody else, you can sign that check over to somebody else. So it makes it the transfer of payment obligations easy. That's a process of negotiation. The party that the party that holds the instrument that's entitled to take payment on it, we call that person a holder. And the way it's properly transferred is pretty simple. If it's signed up to somebody in particular, as a check usually is, or a loan agreement, there's a particular person that's named on there, or a particular entity like a bank that's entitled to take payment. If there's a particular party named, then negotiation is accomplished by endorsing the instrument over to them by the party who's originally supposed to take payment on it, signing it, and then physically transferring it to the next person. If it's not made out to anybody in particular, then physical transfer is the only thing that's necessary. So if it's a check that somebody writes out to simply the bearer of this instrument, or they write just to cash without naming a particular party, then anybody who finds that check can then come take payment on it. But as you can imagine, most people are going to write a check or another draft to a specific party, and the same is true with notes, which comes into play with loan agreements. Now, so the party who's had it properly transferred or negotiated to them is called a holder. But what happens when that person who has let's say a check transferred to them to make payment on an obligation to them, what if it turns out that the check as originally written, there's some problem with the transaction that led to the original writing of the check? So let me put it another way. So I do work for somebody, and he writes me a check without knowing that the work has been completed or not. In the meantime, I owe a third party some money for some work that he did for me. So the easiest way for me to do this is, let's just say it's in the exact same amount, so it's no problem. I got paid $500 for work I supposedly did, but the reason I did that work is because I owe somebody else $500. So to make it easy, I just take that check, and without cashing it, I just sign it over to the other guy. I sign my name to the back of it and endorse it and physically transfer it to him. In the meantime, the first guy who wrote the check now has found out that I did not do the work, or I didn't do it properly, and now he wants his money back because he realizes I didn't complete the job that I was asked to do. So the question is, the third guy who has the check now that I transferred it to, is he entitled to go cash it? Because he wasn't a party to the original transaction. And remember, negotiable instruments are supposed to be a kind of substitute for cash. And so normally when you have cash in your hand, you can go spend that immediately. And so the question is, we know that he's a holder of the instrument if it was negotiated the proper way, which means it was transferred to him and it was signed over. It was endorsed by the party who it was originally made out to. The question of whether he is allowed to now go cash it without regard to the dispute between the original parties has to do with whether or not he's just a holder, but whether he's considered a holder in due course under the law. That's the phrase we use. And basically what it means is the question is, did he have any knowledge of this beforehand? Is he aware of the fact that there was reason to think that this was not a good check? And the UCC gives us 3 things to look at to determine for sure if somebody's a holder in due course. You see them at the bottom there. 1, they have to give value for the instrument. So there has to be some consideration. It can't just be a gift that he was given. And in this example, we know that there is, because we know that there was work exchanged earlier that the middle party owed the third party. 2, he takes the instrument without knowledge that the instrument is overdue or defective, and then takes the instrument in good faith, which is really a part of taking it without knowledge. If he knew that the first guy had screwed over, or the guy in the middle had screwed over the first guy by not doing the work, then we can't allow him to take payment for his work on a check that he knew that he had reason to know was bad. So the first guy is not without recourse. I mean, he's got to sue the guy in the middle, otherwise take up the dispute with him and try to get the money from him rather than just stopping the check that the third guy was entitled to take because he did the work and he didn't know about the dispute or the problems about the transaction that gave rise to the original or the initial writing of the check. So again, just to recap from the last video, we divide negotiable instruments into 2 broad categories: drafts and notes. The only difference really is they have all the other same characteristics of a negotiable instrument: unconditional, signed, certain sum paid by a definite date. The only difference really is the number of parties involved, and a draft is an instrument that has 3 parties. The first party, the drawer, is ordering a second party to pay a third party, which is the payee, the person who's owed the money. And that's why a check is a draft, because a check is an instrument whereby you're ordering your bank to pay a third party. And even if they don't, just so you know, they don't have to take it to your bank, as you know. They can take it to their own bank, but there's a system under the federal banking system that actually is having that bank is communicating with your bank ultimately and confirming that the funds can be released, because it's, again, an order from you for your bank to pay the third party. And then a note is just one promise from one party to another to make payment under those terms, a certain sum of money by a certain date, and so on. That's the maker of the instrument and the payee, and that's a note is what a loan agreement is. It's a promise by you to pay back a certain sum of money under all those other conditions. The book talks about some other types. We're not going to go into every single type of negotiable instrument that's possible. One I'll just mention so you understand why people do these. A cashier's check is, and a money order sort of works the same way, but a cashier's check is a draft. It's a check where the drawer and the drawee are the same party. So this is where you go to your bank, and at the teller stand you give them essentially an order to pay somebody a certain sum of money, or to release a certain sum of money, and they write a check on their own behalf. So this way the bank is drawing the instrument on their own after checking that you already have the money there. So when you take a cashier's check away, you don't have that one last step whereby your bank or whoever's going to cash it has to check and make sure that the money's still there. And so that's why a lot of people want you to pay maybe your rent or some other obligation with a cashier's check or a money order, because unlike a normal check, when you have it in your hand, you know for sure the money has already been can already been accounted for. Whereas with a normal check, you know that they can bounce if it turns out that you don't have the money after the order is after someone attempts to fulfill the order.